Welcome to Shenkman Education. My name is Marty Shenkman. The topic of this video clip is a better, I think possibly better, revocable trust. Revocable trusts are commonly used to avoid probate, but can they do more? The answer is affirmatively yes. There's a lot of interesting applications that can be done with a revocable trust beyond just this sort of standard pitch of avoiding probate. What can you do with a revocable trust? Different things. So for example, let's say you're planning on getting married and you're not comfortable spending the money or the complexity or the cost of maintenance of a self-settled domestic asset protection trust. That's a trust where you put assets in the trust, but you can be a beneficiary. It's a great tool for planning before marriage, because before you're married, you don't have a fiduciary or position of trust responsibility to your spouse, and you can transfer assets into a self-settled trust with an independent institutional trustee and get hopefully pretty good protection if there's a later claim. Matrimonial family lawyers have different views on whether or not that should be disclosed. My 2 cents as a non-matrimonial expert is I would disclose it. I would attach a copy of the self-settled trust agreement and a balance sheet for it to the prenuptial agreement. You should do one because that way everything's above board, nothing's hidden, no one's going to get angry later because they knew everything. That's one. Another application is that if you can't afford to do that, you set up a revocable inheritance trust, and at least you're segregating pre-marital assets or inherited assets so they are less likely to get commingled with marital assets. That doesn't mean that the court won't consider them as part of the marital pot in determining perhaps income, and the laws differ all across the board by state, so you really need to look at your state laws, but at least it helps protect the assets from getting commingled. If you have premarital assets and they're mixed up with marital assets, your spouse puts money in, takes money out, etc., at some point of commingling, you lose any really separate nature. So that's an interesting application of a revocable trust. Sometimes in second and later marriages, sometimes if there's different people, even if you're not married, that you're trying to leave assets to, it might be helpful so they don't all operate under the same document to use a revocable trust that's funded with certain assets. You can always revoke it, you can use them at your whim, but it'll go to different people than perhaps your will. So this way you're not mixing different heirs under the same legal document. It may be a nice way to minimize upset by heirs and to foster more harmony or peace after you're gone. So that's another somewhat off-label application of revocable trust. But the heart of what I wanted to talk about is that revocable trusts so often focus only on planning to avoid probate. But to me, the really powerful use of a revocable trust is to protect you as you get on in years, or if you have chronic disease or disabilities. How so? The typical revocable trust, you could be the person setting up, called settlor, you're the trustee, you're the beneficiary, but that mechanism will help prevent assets that you put in the trust to avoid probate when you die. But you can go further. When you're planning for aging or disability or other health issues, you're going to do a durable financial power of attorney designating an agent to take care of financial matters. But if you set up a revocable trust and you name successor trustees, the assets can already be in the name of the trust. It should be, in most cases, it probably would be easier for a successor trustee to act on those assets than for an agent with the power of attorney. Now, I've had people tell me that, when a certain elderly family member, parent was sick, and for years, they had no problem using a boilerplate power of attorney. I've had far more people tell me it was really hard to get banks and other people to accept a power of attorney. If you use a revocable trust and plan it for using it for disability and aging and things like that, it probably is a lot better in many cases and easier to use because the trustee has title to the asset, whereas the agent under a power of attorney is merely acting on your assets. What can you build in to a revocable trust that may not be the standard fare to give you better protection in these instances? A number of things. Most revocable trusts use your social security number, and that's perfectly fine and that's acceptable. But one of the things that concerns me is identity theft and even elder financial abuse. If a separate tax identification number is obtained from the IRS for your revocable trust, and the accounts, the investment accounts, for example, in that trust are under the name of the trust and the tax ID number of the trust, my observation, my guess, no data on it, is that it's going to be harder for somebody to scam those assets, because how are they going to get access to the number? I also have seen, whether it's factually correct or just what's occurred, that when someone sees that assets, a bad actor sees assets in a trust, it's viewed a little more negatively than trying to manipulate you to get your assets. So it may be better to use a revocable funded trust with a separate tax ID number. Another idea. There's a common concept used in planning for sophisticated irrevocable trusts, those that can't be changed, and that's not our topic of revocable trust, but just like an analogy. Those trusts typically will have a trust protector. It's somebody that could be acting in a fiduciary or non-fiduciary capacity, often non-fiduciary, so they have no inhibition or restrictions on their ability to act as they choose, and different rights and powers can be given to that person. In a revocable trust, you may want to keep that person acting in a fiduciary capacity, but you could give them powers like remove and replace a trustee, ask the trustee for an accounting, change governing law in situs in case you move to a new state or it's better to move you to a new state. If there's a bad actor serving as trustee, kid goes rogue, right, and is spending mom's money on themselves instead of on mom and dissipating everyone else in the family's inheritance, the trust protector can remove them without going to court. If you don't have that mechanism and those powers, the trustee, the bad rogue trustee, bad actor trustee, can use trust money to pay for their defense. And it's really hard often for the other kids to muster up the money to go out and hire a lawyer to sue the trustee, and they may not have what's called legal standing to even sue the trustee because they may just be remainder beneficiaries. So a trust protector is another good tool or modification to a typical revocable trust to make it a better tool for planning for disability. Another concept, you could build in a monitor. It could be in addition to the trustee. You could build in a requirement that an accountant, and I would recommend a certified public accountant, issue an annual compilation of trust activity so that there's a report issued by an independent CPA, and maybe that report has to go to the trustee, to you if you're the settlor, and to the trust protector as well, or maybe even another party. So mandatory reporting can be helpful to provide protection as you get on in years. It's much harder for somebody to do bad deeds, bad acts, steal your money, pilfer funds when there's somebody watching them. You could even put in, if you have health issues, a mandatory independent review, whether it's quarterly or annually, by an independent social worker or, I'm blanking on the name, a social worker or care manager, that's the word, sorry. And the care manager could have to issue the report to the same people. This way, how do you know that you're really being provided for and protected? Does the trustee even really know? There have been some horror story cases where a beneficiary had cognitive or other challenges and they were living in squalor because the trustee never checked on them. If there's a mandatory annual review and report required by a care manager, and they're mandatory reporting persons, so if there's an abuse or an issue, they have to report it, and they identify problems, they'll have to be dealt with. It makes sure that you are protected. So what I've done in the last segment of this presentation is just given you a whole bunch of ideas to make a revocable trust better as you age or have health issues, safer for you. In the beginning, we talked about how you can use a revocable trust to accomplish some pre-marital planning, although not as good as an irrevocable trust, but for many people, that's all they're comfortable doing. So when you hear revocable trust bandied about all the time on the internet is the only way to go, I'm not saying they're not a good tool, but you can apply them in more creative ways and get better protection and more out of it. And in the end, protecting yourself and your loved ones, that's what it's all about. Thank you for joining me. For more information, see shenkmaneducation.com. And please keep in mind that all the information on the video is for educational purposes only. Don't take any legal or other action without appropriate professional advice. Thank you.